Hello student, this side Jitendra Chaudhary, working as an assistant professor over IPM College of Ghaziabad. So today I am delivering a lecture on company law, which is part of the BCom honors fourth semester. So we will discuss about the what is company and what are the features of the company, how which law is come under this category, right? So first we understand what is what is the basic syllabus for the this particular topic. So about if we talk about the syllabus of the BCom honors fourth semester under the CCS University, first unit is talking about introduction to the Companies Act 2013, how the important definition and the incorporations which is related to the company. Now the second unit is talking about the prospectus and the allotment of the securities, and third unit is about the management and the administration. Fourth unit is about the director appointment and the qualification, and the fifth unit which is talking about winding up of the company and what are the various mode of the winding up that particular company. So further we move the first unit which is related to the definition in the Companies Act 2013. Previously it was Companies Act 1956. So first we understand when the Company Act is enacted. So it is enacted on 30th August 2013. If we talk about, it was earlier law which was passed in 1956, which we have already before 2013. It was considering as 1956. Further, the rules are prescribed by the central government, which is the Ministry of the Corporate Affairs. And the Companies Act has been amended twice so far. If we talk about, first we have in 2015, then we have 2017, and amendment of act which is if we are talking about in 2016, it was for the bankruptcy, insolvency and the bankruptcy. So first we understand what is company. So before moving ahead to the proper definition of the Companies Act, according to the Companies Act, first we understand what is company. So company is nothing, it is a group of a person which is associated with common object. So they have some common object and they want to discuss about the common object of the particular company. So that is very important. How the companies work, that is not important, but the part how they are going and what is the common things to that particular common object is, right? So further we move, if we talk about the nature of the company, or before that, in the proper definition of the company is, if we talk about a company incorporate under this act under any previous act, या तो वो कंपनी इस एक्ट के अंडर में है या उसके बाद वाले एक्ट के अंडर में है, तो इट विल बी कम अंडर दैट कैटेगरी. Further we move. So we have some nature of the company which is characterized about how the companies is working as. First we have the corporate personality, and so that is basically how the incorporation form the corporate identity. It has a corporate identity, which means it basically on their name, they operate under its own name, they have on their own name on seal, assets are the separated. So this is about the corporate personality. If somebody is talking about this, so that will be your related to that particular corporate an identity. If we're talking about the limited liability, limited liability means a member debt of the company limited to amount unpaid on their shares. So heavy losses of the company might have suffered. Suppose a shareholder buy 100 share of 10 each and buy 5 on each shares. He had paid 500 rupees, can made a payment of 500 but cannot made a more than 1000 rupees. So whatever the liability they are actually have, they have only up to the extended point. ठीक है. तो इसमें जितनी लाइबिलिटी होती है उसी तक ही वो लाइबल है, बाकी के लिए वो लाइबल नहीं है। वट एवर दी पेड अप अमाउंट इज अबाउट, सो उतने तक ही वो लाइबल है। Then we further move for the perpetual cession. Perpetual cession means a company has a stable form of business organization. Its life does not, affect or depend upon the death, insolvency, or the retirement of any of the shareholder, director, members, and all. It will not affected by these things. So it extend definitely or for the set of the period carry out their mission and the achieve an objective outlated in the memorandum of association. As a result of perpetual succession means the company's membership can be changed from time to time without affecting its continuity, right? So further we move the separate property. That means how the person is legally bound, a company legal person having a judiciary personal entirely distinct from the independent of individual person. So if we talk about a company, not merely sum total of the component member, but it is a something separated from its separation. So whatever the shareholder that capable of the buying and processing, depositing the land under this on, so the corporation is legal and entity which will be company as asset to be wasted by the on, so regulated and the disposals. So that is very important. And the transferability of the share, so whatever the stock, if we can say, so the shares can be transferred easily to one person to another person. The suppose we are I am the real owner, or I have the certificate of the incorporation, that mean I am the shareholder of particular company and I want to transfer that share to another person, you can easily transfer. So the next point is the common seal. Common seal means an organization become a legal body, and with the permanent succession of the common seals, so as I pointed out the earlier, company being an artificial person, as nobody similar to the natural person, such as it cannot sign document for itself. So whatever the document of the particular company, they must be stamped by their seal. So that is very important part. If the seal is not there, that means the official signature and the validity of the document is not be sure. So that is very important point. Capacity to sue and to sue, that means a corporation is a legal entity that can be sued or sued under its own name. So suing means to take civil actions against other for the filing or suits in the court. So that is very important, how the company is reacting on that. A business is right to sue a trigger when the company suffer from injury. So that is very important. Contractual rights, that means an organization can legal body, so it can extend their owners and may enter into a contract under its own name. So that is very important. A corporation is not a trustee for its owner, so shareholder cannot execute a contract. So that is also an important part, how the company is working. And the next point is limitation of action. That means a corporation authority is limited by the memorandum of association. Whatever the mention in the memorandum of association, it will work as it is in that the format and the things that they have given to the public. So that will the objective, the power, and that should be done in proper manner, right? So separate management, like previous said, a member can be properly prosper without being burdened. So by the company as administration may be separated from the shareholders and the member of the company, but they elect their member to the company board of the director to perform administrative activity through their own management staff. So that is very important. As a separate management, they have a separate management which is run by the director and the high profile person and the professionals which is related to the finance, marketing, and all, right? Voluntary association for profit. So any business is cannot run without profit. So as in the case of the company, that is also important part. They have to be earn some profit after the year. So that way, the corporation is profit making charitable organization. It is created to achieve such specific object. So any benefit earned and split among the company as owner and the retained for the possible growth. So one thing is very important, whatever the profit of the company, it may be retained by the company or it can be distributed among the shareholders of the company. So only section 8 is corporation with no profit motive we created, right? So the most important part is this: whatever the profit is earned by the company, it should be distributed among the shareholder in the form of the dividend, right? Termination of the existence. Since it's an artificial judicial person, so corporation does not die naturally. It is stabilized by the statute, so conduct its business in the accordance with the law throughout its existence. So the time period, maybe the company earlier part, they become a reorganize, or they can merge to another company and they can restructure their environment, and how it maybe become a bankrupt. So in this case, the existence of particular company is evaluated, or you can say how the company is affected and the companies terminate their business, and that is very important part. So we discuss about the company, how the company is formed, and what are the basis of, and what are the type of the company. So further we move to this. So if we talk about, we have something called on the basis of incorporation. So one thing is very important. So the the company which is we have categorized basically by 3 or 4 things. The four type, on the basis of 4 type we can categorize the company. First one is according to the mode of incorporation, how the company is incorporated. Then second part is the according to the member of the company, how many numbers of the member are there, so we can you know categorize that particular company. Further we talk about according to the liability of the member, whatever the liability of that particular members, we can categorize upon this. And the last one in the other type of the company. So we have the 4 basis type where the company can be categorized, or you can say the type of the company. So on the basis of incorporation, there are 3 type of company. One is statutory company, registered company, and the chartered company. So first, one by one, we understand what is statutory company, what is registered company, and what is your chartered company. If we talk about the statutory company, these companies are formed with the objective of carrying out businesses which are the interest of the nation as a whole. When a company is running for the growth of the uh, nation, or the growth for the publicly environment, or they are just running for a business, which companies are like the Reserve Bank of India, the Unit of Trust of India, LIC is the one of the part of statutory companies. So these are the company which are the statutory companies, and these companies are run for the welfare of the nation. So these companies are statutory company, right? The next point is registered company. In incorporated company can also called a registered company. So the registered company, these companies are registered under the Companies Act, which is 1956, or the 2013. The registered company can further be classified into various types. They can be classified either on the basis of the number of members, on the basis of the liability. If some company is the registered company, we can further categorize it. Okay. Now the next point is type of company on the basis of liability. So if we talk about the company's liability, limited by the shares or limited by guarantee. So what is limited by share and the limited by guarantee? We will understand how these things work. If we talk about the limited by share, that means a company that has a liability of its member limited by the memorandum to the amount, if any unpaid on the share respectively held by them in term as the company limited by shares. So when the shares, the liability can be enforced during the existence of the company as well as during the winding up. So these are the limited by share. If we talk about the company limited by guarantee, that means a company limited by guarantee is a company that has a limited of its members, limited to such amount that the member may be respectively undertake by the memorandum. So we can say that these are the company which is limited by the guarantee. Further, we move unlimited liability. So unlimited liability, if we talk about the unlimited liability, how the companies are uh, a company not having a limit on it, the liability of the member. So here the members are liable for the company as a debt in proportion to their respective interest. So these are the company which is unlimited company. So type C, which is very important and it's come under exams questions also, type of company on the basis of numbers. So if we talk about the public company, so there is some requirement for the public company and there are some also requirement under the private company. So the basic things we have to understand that the minimum members which we need in private companies 2, and in for the public company we need 7 members. That is very important point. And the maximum number which is in the private company is 50, and in the public company there is no limit. So that is very important. And the director, if we talk about the minimum director, there must be a 3 director, two director in the private company and 3 director in the public company. That is very important point. So transfer of shares, these are restriction on the transfer of shares. If we talk about the private company, they cannot transfer their shares, or shareholder can transfer shares freely without restriction. For public company they can transfer easily. So these are the point where we will discuss how these companies are working. And the last point is one person company. With the implementation of the 2013, several new concept was introduced that was not to existed in 1956, which completely revolutionized the corporate law in India. So one such was the introduction of OPC concept. This led by the avenue of the starting businesses. So giving flexibility with a company and form of the entity can be offered. So while also offering the limited company sole proprietorship or the partnership does not offers. So that's all from the my side. We will discuss the further about the company law. Thank you so much.